Okay, I've started the recording and we will go on record. Good morning. Today is Tuesday, November the 19th, 2024. My name is Sharon Bernardi and I'm joined by my fellow board members, Fred Lauer and William Paulshock, for public deliberation of a hearing that was held on October 16th, 2024 before this panel in the matter of William Faber, property owner of 2420 Holly Neck Road, whose petition for special hearing to approve the existence of a lawful non-conforming use for a boarding house under BCZR Section 104 was granted by an order of Administrative Law Judge Murphy on June 28th, 2024, with specific conditions. And to begin, I want to thank the parties for their well-reasoned memoranda that we've received for this proceeding. And just wanted to open with a general statement that it is generally undisputed that pursuant to County Council of Prince George's County v. E.L. Gardner, that zoning regulations support the elimination of non-conforming land uses. However, in determining this issue that's before the panel today, we have to determine whether the property meets the requirements of a lawful non-conforming use. And there are several factors that we have to work through as we reach that determination. And how I would like to proceed, unless you have any objections, is just kind of go through what my thought process was, and then of course have you jump in and give your position as we go through this discussion.
Great.
Okay, thank you. And so first question for me was, is the property being used as a boarding house as defined by section 101.1? And I know People's Council, as well as the Protestants, they presented arguments on why this property may not be a boarding house and may be some other use, such as an apartment or a hotel. And just for reference, under the regulations, a boarding house is a building, and it's A1, I would say 2, which is not the owner's domicile, and which is occupied in its entirety for compensation by 3 or more individuals who are 18 years old or older and not related to each other by blood, marriage, or adoption. And it's not to include a hotel, motel, or apartment building. And wanted us to begin with the discussion of whether or not we align on whether the property is being used as a boarding house or some other type. And I was leaning toward it being a boarding house only because there, of course, was the testimony that was given, not much additional evidence to support that testimony because we didn't receive any copies of lease agreements, although the testimony said that they were short-term leases. Testimony also that there weren't any like cooking facilities on the premises either. But also there were various code violation complaints that were made, and when they were investigated, they were closed and appeared to have findings that it was a boarding house. But I would like to hear both of your opinions on whether or not you believe it's a boarding house.
Well, I find that the label as a boarding house is it has been labeled as that. But as we do know, non-conforming use comes under stricter burdens of proof other than labels. And so I think that's where my question is going to lead of how we discuss this further. But it does become, and so I guess the first issue is it a boarding house? I think as labeled, They say it is, but it is, in this case, it becomes a strict burden of proof. As you started out, um, you said there wasn't much other than a label, and I find that concerning. So I think that's the way I'm feeling at this point with it right now.
And Mr. Lau?
Yes, to answer the narrow question, I think there was not a lot of evidence on several things, but particularly on that issue that you're addressing, Madam Chair. I think they could have provided photos. They could have had tenants. They could have provided leases of some sort, showed us what the interior looked like. Pretty easy things to do, I think, to convince us that it was a boarding house. I think that perhaps the applicants came in and just said because it was said it was a boarding house, that it was a boarding house. And people had made a couple references in various documents throughout to it being a boarding house, but I don't know that they established, in my mind, sufficient evidence. By the way, I would also agree with you in terms of the memoranda submitted. I thought they were excellent by both parties and by People's Counsel. I think they all three did an excellent job of getting to the facts and the law and applying them to the case. But I don't know, in my mind, if there was sufficient evidence that it currently is a boarding house. So to answer your first question, it looks as if you have some more, but
Well, I think that for the deliberation, we should go through the discussion if there was assumption that it was a boarding house, so we can address some of the other issues. I agree with you that the evidence is very thin on how the property is currently being used. If for sake of discussion, there was a presumption that it was a boarding house just based on what evidence was presented, then I think we have some additional questions. And if I could quickly go through them. One, was it continuously used? So if it was used prior to 2008, when the zoning changed from BL to RC5, and 2008, is it still being used as such? I think that the property seems to have been similarly used in the same capacity from 2007 on, whether that's a boarding house or something else. I think that the nature of how it was being used, although we can later talk about the number of rooms and the expansion and those issues, but I do think that it was being used for rental of rooms in some type of capacity. And wanted to know if you agree.
I would agree with that in general. I don't know that there was sufficient evidence to support the fact that before 2008, I believe that's when the new zoning flipped in, documentation that it was used, and I think there were 9 at that time, or was evidence that there were 9. That's what I jotted down. Again, there could have been tax returns that showed, various things in there that could have proved that. Records of rental type of things. You think you'd have some kind of record, leases if you had them or whatever, some type of documentation, some type of evidence to support that it was a boarding house before 2008. And that was also a very important question for me that, I found kind of lacking in the evidence before us. And then the next question, as there, perhaps you'll get to it, is was it uninterrupted? Was it continuous over that period of time from 2008 until the present, when they're really now first applying for this non-conforming use? And I didn't find sufficient or enough evidence, and maybe you all did, and you can convince me. I didn't find enough evidence to see that there was continuous, uninterrupted, basically use of over that period of time. So evidence support a boarding house, evidence support whether there were 9 units or whatever back then. I think it was lacking in my estimation.
I mean, other than the complaints and, the police reports that people were living in this, this property.
Well,
And then I think there was also a complaint about it storing chemicals at some point, but that
Yes.
supposedly was less than a year.
Madam Chair, that there was no doubt there has been activity uh, for quite a while with that location. But it keeps on going back, and we'll probably discuss this, but of the fact that it is the strictest of the burden of proof to say about that. And it's up to the owner of that property to maintain records, license, documentation. It's easily pulled up by Baltimore County on this property. And the fact shows that it was not quite all done. There's lapse, sometimes 2 years. Um, there's no doubt that there's activity. It just wasn't legal activity throughout all those years. So that's, both councils gave great descriptions of it. You kind of go back and forth after you read them and read them. But the matter of fact is, it needs to be a legal, non-conforming property if it is.
Okay. I'm sorry, I didn't mean to interrupt you. I think whether it was legal or not, it kind of matters, but doesn't matter to me. But it was represented that they had rental licenses at the hearing, that there were rental licenses, but none were produced. I mean, if you had rental licenses over that period of time, then why didn't we see them? But it's represented, I believe, my notes and reviewing some of the memoranda, etc. So even if the the use was there, I don't know that they sufficiently presented evidence that it was continuous from 2008 until present. I just would have liked to seen more documentation of that continuous uninterrupted use over the period of time. And I don't think was asking for the world here. I think that those should be documents that would be available in the normal course of business, even if it's just jotting down notes of who did what when and writing down who paid the rent, whatever. but I didn't see that. That's my thoughts, Madam Chair. Thank you.
I mean, I recall that there were some past rental licenses, but the current ones were on hold because of this proceeding. But I agree with you that there wasn't anything to show that over a period of time that there was some continuous use of this property, which it should be available. And that wasn't presented.
Madam Chair, I believe People Council in their exhibit has history of that was available in Baltimore County records, a fact. And if you go upon them, there is a lapse. So I think that's important.
And I thought it was interesting too that they produced, the petitioner produced a insurance document, but there wasn't record that it was actually insured, that the property was actually insured. It was just an application for insurance. So there were various things that were presented to appear as if there was some type of activity. But then, as you both mentioned, there was nothing to confirm that this activity was going on the premises. And so we probably don't need to get to the other questions, but I think we should at least just state for the record that there would be consideration, given if it was in fact a boarding house on, whether or not that non-conforming use with them adding the additional rooms to the property was an expansion or an intensification of that non-conforming use. But
Do you want to discuss that, Madam Chair? I mean, we can briefly if you like. I mean, I had problems with that at the hearing. I believe I asked a question about related to that. I would see this as impermissible expansion based on reading the cases that I've read and the memoranda and other things. At most, I would allow them nine rooms here because I think that's what it was in 2004. And if we believe any of the evidence, and there is some evidence that says there are a couple different places that there were 9 in 2008, excuse me, 2008, that's where I'd go with that question and basically see this as an impermissible expansion of the non-conforming use.
Mr.
Madam
Pasha?
Chair, sorry, go ahead.
No, I was asking for your opinion.
Good time. I would have to agree with Board Member Lauer on that also. If we resort back to a non-conforming use, that it was dismissive development of that to 18 for sure.
And I guess I could reach that position, but maybe under a different factor, because I do tend to believe that because the footprint of the property didn't change and that it was being used similar to what it was prior to the zoning change. But I think my bigger issue is one of the factors, and I think it's McKimmey, when it says, does the current use have a substantially different effect upon the neighborhood? And I do feel that adding the additional rooms to this property, and I know the permitting piece isn't part of our jurisdiction, but I do believe that that expansion has an impact on the neighborhood based on the testimony of the protestants and just the police complaints and and the other evidence that was presented.
I agree.
I agree. And when we can get into that because that's what I was hoping it would lead to eventually. But I will tell you, this was uh, the first case I believe it came in. It was a boat yard to a marina, yacht club, and then to a office. I think that went to 2014, and so there was a lot of complete different classification of what this was going through over time. Uh, it has evolved to where we're at today, which is concerning. But I guess what's most concerning in my mind, and if it was a non-conforming use of a boarding house or any non-conforming use in general, public health and public safety trumps anything of what's going on. And of course, we had some issues with this location, as you just brought up, uh, from police calls to whatever. Um, we had a lot of issues. I guess the most thing that concerned me most about testimony in that de novo case we just heard was on the recording of 121. I believe it was the second recording, 1 hour and 20 minutes and 50 seconds. Mr. Faber talked about that there was deaths on that property. He states that there's 6 or 7 a year. For public health and public safety, 1 death is concerning. 6 or 7 is striking. To follow that, in the third recording, at right around 1 hour, Mr. Love confirms that there's 6 or 7 deaths. That is a concerning issue. It's a public health and safety issue, but not only to the people who are in that activity, but to the adjoining neighbors, to the community. It is striking. The other striking part is in testimony, and I believe that was probably around 5:31 and 24 seconds in the third recording. Mr. Craig Ronbauer, he says his help goes and cleans that adjoining property's fence that they joined together. He owns the yacht club down there with the boats, where he testified that families, of course, they come to get on their boats on weekends and enjoy the thing. He stated that there are needles and trash. The concerning part is needles on that property line. Mr. Love testified in that recording, later in that recording, that it's due to raccoons getting into the trash and that they're diabetic needles. It doesn't matter where those needles are coming from. It is a public health and safety issue. And not just trash or their appearance. Okay, those things can be fixed. But this is something that is a public health and safety issue to not only to anyone who is a resident or visiting that property, but to the adjoining properties in the community. It's concerning. I have a hard time sleeping after I heard those comments. We actually have a similar thing in the state of Maryland this year, and that was on the beach of Ocean City. That's how severe medical supplies are, wherever they come from, to a community, to people. And I think it's something we have to address here, and it's important. And that falls under 104.8. If this is a conforming use, I know Public Counsel uses a lot of 104 in their memorandum, but they do not have this. But there is code violations that have occurred with this property from, I believe, 2007 all the way up to current. Now, of course, all code violations, most of them, are either done, and probably a majority of them, by community, by neighbors, by maybe even uh, people in general, make calls in. That's how they come about. And most of them are visited, and and uh, most of them are closed, if not 99% of them closed. Okay, but they're an active. This thing has active um, activity with code enforcement, whether they go out to it or not. I believe over the course in page 4 of People Councils, I believe there was 98 degrees of it. I mean, 19 degrees of it. That's not counting all the calls to our Baltimore County Police, and it's concerning, and it's concerning to a neighborhood. It's stated by the owner, by the management, and in since I'm talking, I can't stop now because I'll forget. But saying that, the memorandums were excellent by all councils. But I guess what struck me the most was in the memorandum by the petitioners. And it says in this means even if the board were to approve the confirming the boarding house non-conforming use, the petitioner would be substantially be required to comply with all code and provisions elevated protestants' concern. And if he did not, the non-conforming use could be terminated under the process and outlined by BCZR 104.8 above. Okay. And this is not before the board at this time.
Right.
Because they're saying it is not a conforming use. I don't understand. They're either a conforming use or they're not a conforming use. And council has stated that at this time it's not a conforming use. But if it was, that means 104.8 would terminate the use of a non-conforming use. And all the actions have just occurred. It's hard for me to get over the public health and safety of what's happening there. So I'm kind of going on both ends here. I don't believe it is a boarding house, but if you guys determine it is a boarding house, then section 104.8 has to declare it terminated. That's
And I think for clarification, if we were to find that it was a boarding house and that it had been continuously used for this, non-conforming purpose, that 104.8 would only come into being if after we make that determination and then there are some code violations that are investigated and upheld, then they would have to go through the process, and then it could potentially be terminated at that point if they didn't satisfy those. But But I do believe it goes to that one prong of the McKimmey case. So I think that we have exhausted all of the issues and potential issues to reach the determination. And it sounds like, but want to make certain that you all agree that we don't feel that the petitioner has met its burden in that the property has been used as a boarding house and for the reasons that we just discussed. And therefore, it the special hearing is not granted to approve the existence of a lawful non-conforming use of a boarding house.
I would agree, Madam Chair, but one other thing, if I might, just briefly here. Since there are people that live there, whether it's a boarding house, an apartment, a hotel, a motel, whatever we call it, perhaps this board could, in its order, and I think we probably would need to vote on this or decide this, give them a grace period in terms of when it takes effect. That the effect may be, and my thought and thinking about this would be maybe 120 days after the order is final. And that depends on appeal, et cetera, et cetera. Anyway, but I would think that we should give in fairness to the tenants, give them perhaps, I came up with 120, maybe 90 is the number, maybe whatever. But I just think giving them some time to relocate, because that's really what we're saying you have to do here. So that would be a suggestion I'd have if the board would want to, in addition to the that part of the order, the main part, add this on.
And from the testimony, many may be elderly, and it seems that they were on month-to-month leases. So I do believe 120 days would be reasonable. I do presume that this may be appealed, and they will probably ask for some type of stay during the appeal as well.
Right, I would think so, but
Are you fine with the 120 days, Mr. Paulshot?
Yes, I agree.
Because we do want to be empathetic to the tenants of the property. Thank
Yes,
you.
thank you.
Make certain that that's included in the order. And thank you all for the discussion. And again, I want to thank the parties for their memoranda.
Thank you.
Have a good day.
Thank you, Madam Chair.